Have you ever wanted to know what provisions you need in an agreement of sale? Have you ever wondered what other provisions you may want in your agreement of sale? Have you ever wanted to know how to explain to a weary seller what some of these provisions mean? If so, stay tuned for all that and much more.
Hi, I'm wdolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn.
Welcome to our episode on real estate agreements of sale, with a special emphasis on the agreement of sale that I use with my investor clients. However, before we dive in, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Okay, a well-drafted agreement of sale with investor-friendly provisions is a document that looks vastly different than your local association of realtors form, or any forms that you might get from other investors or from the internet. From the lawyer's perspective, every transaction can have different facts or issues, and states have different laws, and each of these reasons could create the need for customizing an agreement of sale. When I created my investor agreement, which we're going to review in a moment, I worked with several of my highly experienced and respected investor clients to craft many of the provisions in a way that worked for them to get deals done, but still includes the protected provisions that lawyers want to see in an investor agreement of sale. Okay, so generally a real estate agreement of sale must, at a bare minimum, be in writing, identify the buyer and seller, must be signed by both parties, adequately identify the property, include the purchase price, and possibly a closing date and condition of title. Now, is that all you want in your agreement of sale? Absolutely not. In fact, if an attorney only included these provisions in an agreement of sale, it would be malpractice. Okay, so let's discuss my Delaware agreement of sale. Okay, so let's talk about my agreement of sale, which you'll notice is called a purchase and sale agreement. These are synonymous terms, so don't get caught up in that. You'll notice that it also starts with a summary of purchase and sale agreement terms. So this helps with the idea that investors like to have as short a document as they can possibly get for an agreement of sale. But from the lawyer's perspective, you need to have certain provisions in this document, right? It can't just be a one-page agreement. It can't be a napkin agreement. It's not going to protect you the way you need to be protected. So the compromise here, when I was working with my seasoned investor clients to create this document, was to have this summary on the first page that captures what, for the most part, for the seller is probably going to be the most critical terms: the purchase price, the closing date, the whether there's any contingency provisions and when they expire, and of course it captures the basics too: the names, the addresses of the parties, and that kind of information. It also has a place for the buyer and the seller or sellers to sign. So that way it feels like it's stronger than it is. I mean, that first page is kind of ceremonial to a certain degree. It's not really adding anything to the agreement. It's just sort of a summary of certain terms. It really doesn't need to be signed, but it just makes the seller feel better. So the seller can look at that page and say, I'm okay with the purchase price, I'm okay with the closing date, I'm okay with what's on this sheet of paper, I'm signing it, the buyer's signing it. So this has to be this has to be the information, right? This is the important information to me. I understand it, I'm okay with it, I feel good about it, I'm willing to go ahead and sign this agreement of sale. Now, the seller also needs to sign later in the agreement of sale, agreeing to all the other terms, because the main part of the agreement starts on page 2. The first paragraph of the main part of the agreement captures a lot of those minimum requirements: the names of the parties, the property address. Now, with the property address, you're also going to include the tax parcel number, so you really lock in so there's no doubt as to which property you're talking about. Sometimes it's even multiple parcels, right? And you want to make sure you're capturing that as well. Now, this agreement contemplates that you're going to enter into it as the buyer by way of your company, which you should always have an LLC when you're purchasing investment real estate. Now, as to why it's an LLC versus a corporation, we have a different video on that, so that's not really what this is about. But I default to it being an LLC. If you do use a corporation, then you're going to need to change the LLC to Inc. or Corp or whatever your corporate ending is, and then change that a Delaware limited liability company to a Delaware corporation. If you have a Pennsylvania LLC, it's going to be a Pennsylvania limited liability company. If you have a Pennsylvania corporation, it's going to be a Pennsylvania corporation, and so on. All right, so let's talk about the agreements section. Section 1 is pretty straightforward, I think. Just says that you're going to buy the property and the seller's going to sell the property pursuant to the terms and conditions of the agreement. Now, in section 2A, this is where we're going to list the purchase price. This first blank confuses a lot of people. What you're going to do is spell out in text the words of the purchase price. So if it's $100,000, you're going to write ONE space 100, HUNDRED, space 1,000, THOUSAND. And then in the second blank, which is the line below, you're going to write the numerals 100, comma 000, and we already have the .00 in there. Similarly, in section 2B, you're going to do the same thing for the deposit. You're going to write out the text, and then you're going to write the numerals. On line 2 of section 2B, you're going to write the name of the deposit holder. So if there's a deposit on the deal, it's usually going to be the closing attorney or the settlement agent if you're in a different state, although this is really our Delaware purchase and sale agreement. So if you were using my firm, for example, you would write Dolan Law LLC on there, or whatever the firm is, you would write the applicable firm who's going to hold that, and that's usually going to be the buyer's settlement attorney. Section 2C explains that the balance of the purchase price is going to be paid at the time of closing. Section 2D says the deposit is going to be credited to the buyer against the purchase price, which, this is not controversial stuff. This is just kind of mechanics making the deal work the way it needs to work. Now, section 2E describes a little bit about what's going to happen to the deposit under certain circumstances. And it's just, it's dealt with a little bit later too, but it just explains here what's going to happen with that deposit. Section 2F explains what the deposit holder is doing and not doing, and how you need to communicate with the deposit holder. This is really to protect the deposit holder. If you don't have language in your agreement of sale to deal with this issue, there's going to be a lot of attorneys or law firms that aren't going to want to take the deposit, and really because they don't want to get sued because you have an agreement that's really unclear that if A happens, what happens to the deposit? If B happens, what happens to the deposit? This happens all the time. I'll have clients that'll say, Bill, I want to send you a deposit for this deal I got coming up. Well, you guys hold those, right? And my response is always, well, what are the terms of the deposit? And the clients usually, well, what do you mean? And I say, well, who gets the deposit if you're not able to close for some reason? Who gets the deposit if the seller can't provide clear title? Who gets the deposit? I go through these different scenarios, and a lot of times clients are like, oh, I don't know. We didn't really decide any of that. That's not in the agreement. Well, if I'm going to hold money, I want to know that. I kind of want to know, who am I going to get direction from? What's the standard? How can I rely on it? How's it going to be communicated to me? And that just gives me more comfort that if something goes awry, I'm going to have some mechanism to get rid of that deposit, so I don't get either stuck holding it, or we don't get sued by somebody in the deal to deal with it, which happens. All right, section 3 deals with the closing. So I prefer the most simple formulation that you can with respect to closing, that you just have a date. The closing of the conveyance of the property will be held on or before such and such a date. However, I do build in this ability that if you need more time, that you can automatically get a 60-day extension by providing an extra deposit. And you put in the amount here. It could be $100, it could be $10, whatever it is. And you just provide it to the deposit holder, and you have bought yourself an extra 60 days to go to closing. The blank you're going to see here has to do with the buyer's attorney's office, just where you're going to have closing. Just whoever you're using, just put their office address in there. It's not a requirement. It just makes it a little bit clearer for everybody what's happening. Now, the next provision in Section 3 is important. At the sole discretion of the buyer may require buyer's attorney to use separate buyer and seller settlement statements at closing, and in such event shall not merge the information or disclose it back and forth. So what this is getting at is on a wholesale deal or an assignment deal, you as the buyer may not, or as the wholesaler may not want the seller to know the assignment fee, or you may not want to highlight it to them, right? And so you may want to try to have that information only disclosed on a settlement statement that you are going to see. Now, a lot of settlement agents are uncomfortable with that because they feel like, well, I don't want to, as a settlement agent, get sued for aiding and abetting somebody ripping somebody else off. If you're making money on this, what's the big deal? Why shouldn't the seller know, unless you're afraid that they're going to think you've taken advantage of them? And if that's the case, the settlement attorney doesn't want to be in the middle of that. But if you have this kind of provision in your agreement, you and the seller have pre-authorized this separate settlement statement concept, and you have agreed that you as the buyer are going to decide whether and to what extent you're going to do that, right? So it takes some of the heat off of the settlement agent, because the settlement agent also has an obligation to do this transaction the way it was agreed to on this agreement of sale. The settlement agent can't read this agreement of sale and just say, well, I see what they agreed to, but I'm just going to do whatever I want anyway, right? No. The settlement agent follows the agreement of sale. The agreement of sale is like a roadmap to how the settlement agent's going to conduct closing and build the settlement statement. And that's going to be a recurring theme that comes up in a few of these different provisions. Now, after this, you'll notice something that we have the seller authorizing the settlement attorney to share with the buyer and realtors, if there are any, a closing disclosure, settlement statements, and so on, and to have the closing occur in the same room. Now, this is something that came from the amendments to the Real Estate Settlement Procedures Act, that's generally referred to as TRID. There's been a lot of protections built into RESPA as a result of TRID, and settlement agents have been a little confused. Some of them are a little more conservative. They don't want to share information without some kind of joint consent. Now, the Delaware Association of Realtors form has a very similar provision like this built into it, allowing this sharing of information, and that just protects the settlement agent, so that if information is shared, it's the settlement agent is not going to get in trouble for violating RESPA, because it's been approved by both parties. Now, in case you're a little bit confused, I know we've got one provision that says the buyer can keep all this information separate, and you got another provision that says, well, the seller authorizes all the information to be shared and combined. And Bill, aren't those contrary concepts? And the reality is, no, they're not, because the seller authorizing the settlement agent to share information and merge it is different than the buyer having the right to make the final decision as to whether that information is going to be consolidated and merged onto one form, or to be kept separate on different forms, right? So you want the seller, as a settlement agent at least, you want the seller to authorize, but as the investor, you want to have the right to make the final call on whether it's going to be done that way or not. Now, personally, I would recommend using a merge statement, putting all the information in there, because frankly, it provides you, whether you're the buyer or wholesaler or whomever, it provides you some cover from the seller too. So the seller can't say, well, I didn't know what was going on. You ripped me off. You did this, you did that. From my perspective, it's better to just get it all out there, put it out there. And I can tell you, most people actually have a very hard time reading settlement statements, because it's sort of done in almost an accounting fashion. Look at people that are in the mortgage business, lenders who've been doing this for a long time and have looked at hundreds or even sometimes thousands of these things, realtors, most of them, the overwhelming majority of them cannot really decipher the settlement statement. And when I do deals, I explain the settlement statement to both parties, but I only explain the buyer side to the buyer and the seller side to the seller. I don't explain the opposite sides because those aren't the numbers that directly impact that party. They're on the form generally because most of the time I use merge settlement statements, but I'm not going out of my way because I'm already providing people with so much information that I can tell they have a hard time digesting. I'm not going to throw in a lot of extra extraneous information because as a lawyer, for me, my goal is to just make sure people understand kind of the fundamentals of what's happening and not overload them with a bunch of information that's just going to make it harder for them to understand. And I think most settlement agents do it that way. I don't think what I do is different than most settlement attorneys. So for property access, this is so that you as the buyer, it authorizes you to get access to the property and even put a lockbox on the property and put a key in it. So you can have your inspectors come in if you're going to do inspections, your contractors, partners you have, if you're going to wholesale the deal, potential buyers, whoever you're going to have come through that property, it gives you that immediate unobstructed access to the property, which is important to an investor. Section 5, the quality of title, says that the title has to be provided good and marketable. It has to be insurable or regular title insurance rates. These are provisions that you want. Well, for whatever reason, I see this missed a lot in these agreements that investors bring to us. And this is like a critical provision that you need in this agreement. You need to make sure you're going to get good title from the seller. 6, contingency. So I've structured my agreement of sale to have options. So, right, you can select an inspection contingency, you can select a financing contingency, you can select an appraisal contingency. That's 6A, B, and C respectively. Or you can select 1 or 2 of those, you can select none of them. And the way you select them is you initial and have the seller initial on those lines to the left of the letters, A, B, and C. Or you can just write NA if it's not applicable. And if you're not going to use 1 or 2 or even all 3 of them, you can use that as a selling point to the seller to say, look, I'm waiving these rights that I have to these inspections to try and make this a little bit better, a little more enticing of a transaction for you. And I have some clients that say they actually really like using it that way. Some people I've had have requested me to customize this and say, I'm never going to use a financing or appraisal contingency. I'd rather shorten the form up a little bit. So let's delete those and kind of restructure this a little bit. And I have done that for people, but many of my investor clients really like being able to write NA when it's not applicable and show the seller that they're giving something to the seller as kind of a feel-good type of item. Now 6A, the inspections, I've defaulted this to 21 days. It doesn't need to be 21 days, obviously. It can be 10 days, 14 days, 28 days, 60 days, whatever. What I would say though is you have to be careful. You want to make sure if you're going to change that number that you change both the text and the numerals, right? So the TWENTY-ONE and then the numerals in the brackets or in the parentheses rather. You want to make sure you change both of them if you're going to change it. And then again, initial to the left side of A and have the seller do the same. Now, if you're going to have an inspection provision, you're not buying the property as is. I mean, I hate to break that to you. I know that this causes such a stir with investors. Some of them get really worked up about this. But if you're buying the property as is, you are buying the property in the condition in which it is. If you have an inspection provision that says, well, I might not like the way this property is, and therefore I may want to cancel or terminate this agreement because of the condition in which the property is, it's not as is, right? You have an inspection contingency. So they are, from my perspective, and I think most, speaking for other practitioners, but I think for most practitioners, they're mutually exclusive concepts. You can't have the right to cancel a deal and be buying it as is at the same time. Now, you could still explain to them that this is just kind of a worst case scenario. You don't really intend to use this provision unless you find something catastrophic or whatever. But that's going to be something that's in a conversation with the seller. But this is written to be very broad, to give you the ability to cancel if you find anything you don't like about this property. Doesn't matter if it's in a home inspection, pest inspection, stucco inspection, whatever type of inspection you do. If there's anything about this property you don't like, as long as it is within that period that's listed in 6A, and as long as you terminate properly, you got to send notice to the seller in a certain time frame. As long as you do that the right way, then you can get your deposit back and you're out of the deal. Now, this is a little different than agreements like the Delaware Association of Realtors Agreement of Sale, which breaks the inspections up into the different subcategories of inspections. It doesn't need to be done that way. I have had a lot of clients who think that because that realtor form is done that way, that's the way they all have to be done. And they get kind of confused about this one sort of umbrella inspection contingency. But this provision is drafted more for like business deals. And this is the way commercial deals are done. This is the way some other business transactions are conducted, or business purchases. And here as well, this is, from your perspective, it's sort of a business deal, right? I mean, this is a business deal for you. You're not an end buyer, and this property is probably not in phenomenal condition. It probably needs work. It may need a lot of work. Okay, so 6B, the financing contingency, you're going to need to fill in your commitment date. That's the date by which your lender is going to issue you a commitment to give you a loan. That's, again, only if you select the financing contingency. And I will say most of my clients, even though, and I see that I do a lot of lender rep too, so I know this happens with a lot of other clients, do not select a financing contingency if they're going to use like private money, hard money. If they're going to use a credit line that they already have on another property, maybe their primary residence, whatever the case is, a lot of investors are not selecting financing contingencies because you're trying to get the price down as low as possible. And the more you hit the seller with, well, I want inspection contingencies and a financing contingency, and it has to appraise for a certain amount, you start to do all these other things, and all of a sudden the seller's kind of like, well, why do I want to do this deal with you, right? So if you're gonna get them down to the lowest possible price, and if you're going to have an inspection contingency, which I do recommend, I highly recommend that, and that you really investigate the property to make sure there's not a lot of problems with it that you're not contemplating. That the financing contingency, if you can avoid using it, I would say avoid it. If you can avoid the appraisal contingency, avoid it. Try and give the seller a good reasonably short closing time frame to try and sweeten the deal for them. But at the end of the day, if you really truly need the financing, then you may need to select that provision. So it's, if you need it, you use it, right? If you can avoid using it, or if you don't need it, then I would say avoid it. Appraisal, it's pretty rare. You're probably not going to use that all that often, but I've had some situations where some of my buy and hold clients have used this provision because a lot of times properties that cash flow really nicely are in areas that aren't that great, that the values are just not fantastic. And you want to be careful not to overpay. And sometimes it's easy to look at a property and say, well, I'm going to pay $80,000. It looks like the rent's $1,100 a month. That all looks great. But, what if the property really only appraises for $60,000 or $65,000 because the area is really not that good, right? Do you really want to pay $80,000 even if the $1,100 works? I hope not, right? I hope no. You might be able to use that to go back to the seller and renegotiate, because you'll have the right to terminate the agreement if it doesn't appraise for the purchase price, right? So you could potentially say, okay, well, we'll do the purchase price at $80,000, but I'm going to select this appraisal contingency because, man, if this thing doesn't appraise, I'm not going to buy it at $80,000 if it appraises for $60,000, right? And if you get that appraisal done, then you might be able to use that as leverage to get the seller to lower the seller's price. Even if the seller doesn't lower it all the way down to $60,000, maybe you get it down to $70,000 or $65,000 or something like that. All right, Section 7, the apportionments. This is important for the settlement agent because the settlement agent needs to understand how the property taxes are going to get split and how the transfer taxes are going to get split. It's sort of a logistical requirement to building the settlement statement and getting your deal to the table. So in this provision, it essentially says that the seller is going to be responsible for the property taxes up through the day before closing, and then the day of closing and afterwards, the buyer is going to be responsible. That's normally the way these deals work. It is possible sometimes to have that burden fall all on one party or the other, but you got to be really careful. Sometimes buyers get overly enthusiastic and they say, well, I think the seller already paid the property taxes, so I want to say that, the seller's not going to get any prorations. Basically, I'm going to take responsibility for the property taxes because, I think I'm going to benefit somehow from that. But you got to be careful, because what if they haven't paid the property taxes? What if they haven't paid for the last 3 years or 4 years? You don't want all that responsibility, right? You could all of a sudden, you think you're going to get yourself a $500 or $1,000 benefit, and you could end up getting yourself a $3,000 loss on it because you've assumed all these back property taxes that they didn't pay. So you want to be careful about that. It's better, it's easier, cleaner to have the responsibility on the seller for the property taxes up through the day before closing, and then they're on the buyer. They get adjusted. Whatever debits and credits need to be made to make that work, the settlement attorney will make those on the settlement statement to affect that. It can be a little confusing when you're looking at it on the settlement statement, but conceptually, this is what they're accomplishing almost 100% of the time, unless you've somehow selected something else in your agreement of sale. That's what's going to happen, right? That's what's normally drafted in these agreements of sale. The same thing with the transfer taxes. This agreement of sale, my agreement of sale, has, and you'll see this, it's the second sentence in section 7, seller and buyer shall divide equally and pay all real estate transfer taxes. It doesn't have to be that way, right? It could be all the buyer, could be all the seller, it could be split. The sort of the default in Delaware is to split it between the buyer and the seller, but you can do it different ways. And I have had some clients who got such an amazing deal that they wanted to just pay the transfer taxes. They wanted to try and make the closing go as smoothly as possible, least amount of questions from the seller as possible, and say, I'll take it. I'll pay that. Don't even worry about it. I'm gonna put that on my side of the ledger. Section 8, the indemnity. This is for the deposit holder. Now, on the Delaware Association of Realtors form, the realty offices have this too, have this indemnity. So what this is basically doing is saying, okay, now that there's no realtor usually involved when you're using one of these agreements, but you could be using a realtor. But whoever is going to hold that deposit, whether it's going to be the realty office or the closing attorney, whoever it is, they want this indemnity protection, right? They don't want to get sued and have to put time and their own money into getting thrust in the middle of an argument between buyer and seller on one of these types of situations over $500, $1,000. They don't want to be in that situation, and frankly, you don't want to put those people in that situation. They may be reluctant to take the deposit from you unless some of these provisions are in your agreement of sale. Okay, section 9, the survival provision. This is important because we want the seller's representations, which are going to be a little bit later in this agreement, we want them to survive closing, right? And at common law, they didn't. At common law, they just evaporated. It's a little more complicated than that, but just to give you a kind of an easier way to think about it, they just went away at closing, right? They technically merged into the deed, but unless they were recited again in the deed, they went away. They weren't preserved. So this is our way of preserving them so that if there's a problem, if there's mold in the walls and seller didn't disclose a big water leak to you, then you might have some recourse against that seller. Now it can be a little bit tricky if you have a distressed seller. There might not be that much to go after the seller for, but in any event, you would rather have more options than less to try to protect yourself. Section 10, risk of loss. This provision gets missed, quite frankly, in many agreements of sale that I see that investors bring to me. or it gets covered in a way that doesn't really work. Like I saw one recently that said the seller will keep the property insured. And immediately I think, okay, well, here's a bunch of issues with it. Who's the benefactor of the insurance? Is it the seller or the buyer? Right? It doesn't really help the buyer if the seller gets all the protections. What kind of insurance? What is the amount of the insurance, right? And so let's dial it back for a second. At common law, once the buyer entered into an agreement of sale, the risk of loss to the property shifted from the seller over to the buyer, meaning you enter into a contract to buy the property for $100,000, the next day it burns down, you don't want to pay $100,000 for it, right? I mean, at that point, it's not worth what it was the day before, right? So just having a policy of insurance doesn't really help with that, because again, you have these issues of, well, who's the benefactor of the insurance? If it's just the seller might take the money and run and say, you still got to buy the property from me for $100,000. Or the seller might have some other type of insurance, some type of liability insurance, but not property and casualty to have the property rebuilt. Or they might have inadequate insurance. If it's a city property and they've got $50,000 of coverage to rebuild the property, but the property would cost $110,000 to rebuild, that's not going to work, right? That's not good enough. So this risk of loss provision says if there's damage or casualty to the property, that you as the buyer can just terminate the agreement and get your deposit back, right? And that's what you want. That's shifting the risk of loss back to the seller so that you have the right to terminate that. Hey, if that property goes down in flames, then I can get out of this deal. And really that risk is on the seller. Same thing for eminent domain, that's 10B. If the state decides they want to widen the road and take part of the property or something like that, you have some protection in here. It's not a huge risk. What's the likelihood of that happening? It's pretty low, but it is a risk out there, and there's a fairly easy way to protect you on it. So why not? Why not cover you for it? Section 11, the assignment. This is going to be really important if you're a wholesaler or doing assignment deals. You're going to want the right to sell your interest in the agreement of sale to someone else. And this provision pre-authorizes you to do that and essentially says you don't have to get the seller's consent. It goes a step farther to say that you would actually be released to the fullest extent permitted by law, right? So let's read it. To the fullest extent permitted by law, upon such assignment, the assignee shall possess all the rights granted to the buyer under the agreement of sale, and the buyer shall automatically be released from all of its obligations under this agreement, subject to the indemnity of the deposit holder. So what this is saying is once you assign it to someone else, you're released. Now, I'm going to make a note here. So I do have some concerns that a court may not like this provision. And especially if you have not disclosed to the seller to whom you assigned the agreement and given them contact information and given them reasonable notice, right? Like you don't tell them 6 months later or a year later or after you get sued, but you tell them around the time that you do it, you tell them to whom you've assigned it, you give them contact information, you've got a much greater likelihood that a court is going to enforce this provision. If you don't, there's a chance the court's going to say, no, that doesn't make sense. We're not going to enforce that provision. Section 12, remedies. So this one we're going to get into more detail. The first sentence says if the seller defaults, the buyer has all of its rights and remedies at law. So if you want to sue the seller for specific performance, basically get the court to force the seller to sell you the property, which it can do and it does do, and or you could sue for money damages. On the other side of that, you do not want the seller to have all those same rights and remedies, right? You don't want the seller to be able to chase you down the street per se. You want to have a limitation on the seller's rights. And so this section 12 essentially says that the seller, if you breach the agreement and you haven't cured your breach before the seller terminates the agreement, right? If you cure your breach before the seller terminates, you're okay, the agreement's in place, seller can't terminate. If you breach and before you've cured, the seller terminates the agreement, then the seller can only get the deposit and the additional deposit if there is one. That was that 60-day extension period we talked about a few minutes ago. Or if there is no deposit, then can only get $500 from you. So let's talk about this. So we're limiting your exposure to the deposit because it's generally a pretty low number. It's generally $100, $500, $1,000. It's a reasonable amount of money. Now, sometimes investors do deals where there are no deposits, right? So we really don't want to have an agreement where you've got absolutely nothing to lose, right? If I breach, buyer, if I breach, all you can do is get my deposit, seller, but I have no deposit on this deal, so I have nothing in this, right? There's nothing you can really come after me for. That is generally considered an illusory agreement and is not enforceable. So we don't want that kind of provision. We don't want that issue, right? So the way I have cured that is to say, if there is no deposit, then you are liable for $500 if you've breached, right? And so then your maximum exposure is $500, and the seller has no other rights and remedies at law or in equity. And that's what we want. We want to limit that down. That's one of the ways that we protect you in the agreement. Of course, one of the other ways I've recommended is that you enter into this agreement of sale through your company. And hopefully that company doesn't have a lot of other stuff, right? You don't want to put too many assets all in the same company. You want to try and limit that. You know, I have that in other videos that you guys can access. But you've got your LLC protection. That's number one. Number two, you've got this limitation of liability protection as well. Okay, so now we're going to move on to section 13. Here, just like in section 6, where you had a couple of items you could explain to the seller, hey, I'm going to waive this, I'm going to waive that contingency. Here is a provision that you can use that's also for the benefit of the seller, right? So I have this in here for a couple of reasons. One is it provides notice to you of radon and lead-based paint issues to keep you on your toes, to keep this on your radar. But it is also serving the purpose of acting as the disclosure from the seller to you on these two issues. So the seller doesn't need to provide you any more information on radon or lead-based paint. Based on these provisions, you're acknowledging that you, as a sophisticated real estate investor, understand them. They're hardwired into the agreement of sale. And the seller really does have an obligation to disclose this information to you. And if it doesn't, can have liability. So that is a benefit to the seller and also acts as a reminder to you. Section 14, the attorney's fees provision. So these provisions, number one, are not included in the Delaware Association of Realtors Agreement of Sale. They are not in a lot of the investor, I don't know if they're pulled from the internet, or I'm not really sure where the investors get these agreements, but they're not in a lot of those either. You want an attorney's fees provision as the buyer because a lot of times the sellers realize that they're basically giving the property to you at a tremendous discount and they start looking for a way out. And you want to have as much teeth as you can possibly have to hold the seller's feet to the fire to sell you the property. And one of the ways you do that is with an attorney's fees provision. That if the seller breaches and you have to chase them down and hire an attorney and pay $5,000 to $10,000 in attorney's fees, well, they're going to have to reimburse you for that. And if there's a lot of equity in the property, it's not that hard to get that from them. It also plays into the calculus that the seller side has, right? So when the seller meets with an attorney and the attorney says, well, look, if you lose the lawsuit, you might just not lose the property or have monetary damages to pay, but you may also have to pay for the buyer's attorney's fees and expenses in addition to the seller's attorney's fees and expenses. And so it can shift the balance and give you a lot more leverage in trying to keep the dispute out of court. Okay, so let's look at time is of the essence, which is section 15. At common law, real estate transactions were understood to be delayed a lot, right? And I mean, your experience is this, I'm sure, as well, where they do. There's lots of delays in these transactions. But to make these dates firm, you need to have this time is of the essence provision in the agreement, which basically says, hey, these are firm dates, they're firm times, they are what they are, they're not general estimates. Okay, the next section is section 16. It's the whole agreements and agreements section. This provision does a few things. This is kind of more of a lawyer's provision, but I'm going to explain it to you because who knows, you might get a question from a seller about this. So number one, it says whatever's in this agreement is the entire deal. There's not other kind of side agreements that are not on this paper. It also says that to amend the agreement, both parties have to agree and essentially sign a document amending this agreement, except where you assign as the buyer your interest to someone else. That is expressly carved out because we need that to happen, right? We don't want you to have to go get the seller's consent to be able to do that. All right, the next provision is section 17, governing law. This one's pretty straightforward. It says that Delaware law is going to govern the transaction, which I think would be everyone's expectation and shouldn't be controversial. Section 18, the counterparts. This is one of those kind of practical ones too, that it explains that everybody doesn't need to sign the same sheet of paper, right? One party can sign one sheet of paper and you know, the other party could sign another sheet of paper. But I would recommend at some point assembling all of the full text of the agreement, all of the initialed and signed pages, putting them all together, scanning them into a PDF and emailing them to whoever's involved in the transaction and say, hey, you know, here's the fully assembled, executed version of the agreement of sale. If you're not going to just sit there and sign in person, right? If you're going to sign in person, I would recommend print out 2 copies. You and the seller both sign a copy, and you each get a fully executed copy of the agreement of sale. The counterparts provision also indicates that you might do this remotely, right? You might sign it and exchange signature pages by way of PDF, and that's going to be an enforceable agreement too. And it also contemplates you could use DocuSign or some other similar type of program to sign these documents. Section 19, the severability provision, indicates that if a court doesn't like one of the provisions in this agreement, that they're just going to strike the one provision and not invalidate the entire agreement. So just like we talked about earlier with that potential release of the buyer, if the buyer assigns the agreement to someone else, if a court doesn't like that provision, we don't want the court to invalidate the entire deal, right? We just want the court to say, well, we're not going to enforce that one thing, but everything else we're going to enforce. And this is your agreement between buyer and seller that's the way it needs to be done. Section 20, the representations and acknowledgement section, is important. So 20A says the seller represents that it's disclosed all of the material defects to the buyer. This is important, and this relates back to our conversation in section 9 about the survival provision, that this is going to survive. So the seller already has an obligation at law to disclose material defects. But we don't want that to get lost at the closing, right? We want to preserve it. We want to be clear. We want to be as clear as we can that obligation and that liability is going to extend beyond closing, and this is how we're doing that. 20B and C are really if one of the parties is a company, saying that the company is duly formed, validly existing, in good standing, and the signer has the authority to sign the agreement, which in a lot of cases may end up benefiting the seller, right? Because if you're the buyer with an LLC and you have just a regular individual or individuals on the seller side, that's really a benefit to the seller that you're making that representation to the seller. 20D, this is a provision that I added years ago just to provide a little additional cover for a buyer that says the seller acknowledges that the buyer is a real estate investor and intends to resell the property or sell and assign the buyer's interest in the agreement for a profit. And so it's not a requirement at law. You don't have to tell someone that you're in it to make money. But in case down the road someone tries to say, well, you ripped off my elderly parent and we're going to come after you. They didn't understand what was going on. Well, we've got an agreement in multiple places that indicates you might make money. This is one of them, right? Where you're saying you're in it to make money. That assignment provision way back in section 11 also says that you may assign or sell your rights under the agreement for consideration, right? For money, that you're in this to make a profit. And we're disclosing this to the seller side in several different places in here to try to just make it clear that that's what you're in this for, right? Now, hopefully you're also saying that to the seller. I think it's just better if everybody understands what's going on. And I know a lot of my better real estate investor clients need to explain that, right? They need to explain the dynamics to get the seller comfortable with a low purchase price, right? They need to explain, look, this property needs a lot of work, and an end buyer really isn't going to fork up the kind of cash that's required, probably doesn't even have the kind of cash that's required to renovate this property. And so this is essentially a property that only an investor is going to buy, and an investor isn't going to do it for free. If an investor is going to pay closing costs and put up a whole bunch of money, put in a ton of time, the investor has to make something, right? It doesn't necessarily need to be a fortune, but there needs to be a profit margin in there. And I find a lot of my best investor clients use that as a way to walk the seller through how they are arriving at the purchase price, and to get the seller comfortable, frankly, that it is a reasonable price under the circumstances, and that they're not just getting hosed on the deal, basically, which it would, it's not good if the seller thinks that, because the seller's going to be a lot less likely to want to sell you the property if they think the purchase price is unfair. All right, section 21 is the sealed instrument provision that does two things. So a document under seal in Delaware does not need to have consideration. The other thing is it extends the statute of limitations, which is otherwise 3 years for a contract, to 20 years. You will also notice that when we get to the signature lines. We'll see that in just a few moments. Section 22, additional terms. If you have additional terms, this is where you would add them. I always recommend, if you're going to add additional terms, talk to your closing attorney, or if you use someone like me outside of your closing attorney to help you with agreements and your LLC work and the like, come back to someone like me to help you with writing that information in. It generally doesn't get worded very well, and it's a lot harder to enforce if it's not described the right way, whatever those additional terms are. 23, inclusions. This is where if you want the dishwasher included, the stove, whatever, you list it here. Exclusions, if the seller wants to exclude certain things, maybe they bought a new stainless steel refrigerator they want to take with them. Maybe there's some kind of light fixture in the property that they want to keep, whatever the case is. That's where the seller would indicate that. Now, as for the signature page, which this is the last page of the document, first I'm going to touch on the witness concept. So witnesses are recommended. They are not required. It's not a requirement of law to have someone witness the signature, but it provides additional evidence that it was, in fact, that person who signed the agreement of sale, in case later on they say, well, that wasn't me, I didn't sign that, right? That's the function of it. That's the same thing for when you have something notarized. And this agreement does not need to be notarized. Sometimes I have clients who will ask, well, I see this seal word after the line where I'm supposed to sign. Does that mean it needs to be notarized? And no, this ties back to that sealed instrument concept that we just talked about a few moments ago in section 21, which again means that the agreement does not need to have consideration, and it extends the statute of limitations to 20 years. That's what it's for. It has nothing to do with the document being notarized. Of course, you could have the document notarized if that's practical for everyone involved. Great, do it. If not, try and have a witness. If neither one of those are practical, then you can just have the party sign it. Just know down the road, if someone tries to deny signing it, it's just going to be a little trickier to prove that because there's no witness or notary involved. Now, if you've got a lot of correspondence, email correspondence and the like with that party, maybe you do in fact have some evidence that will help support your argument. Under the seller's signature, you'll see name, colon, and a line. That's where you're going to print or type the seller's name. If there's more than 2 sellers, then you can copy and paste all these lines and add more blocks in for sellers to sign. On the buyer side, I've assumed it's a Delaware LLC that is the buyer. Obviously, you can see that by the signature block. If it is a Delaware LLC, then just add the name before the LLC. There are other corporate endings you could use for an LLC, but that's by far the most common. If yours has a different designation at the end, it's not LLC. If it's limited liability company, or if it's L.L.C, whatever the case is, conform it to whatever the actual legal name of your company is. If your LLC is from a different state, change Delaware to whatever the applicable state is. If your company is a corporation, then you're going to need to delete the LLC and just write in the full legal name of your company. And then you need to change the phrase after that that says a Delaware limited liability company to whatever it is. A Delaware corporation, a Pennsylvania corporation, a Maryland corporation, whatever it is. And then you're going to have your signature and then name, colon, and then either again, print or type your name, and then title. This is where you're going to put your capacity, your member, your manager, if it's a corporation, you might be the president of the corporation. Whatever it is, type in your capacity. You always want to include your capacity and, of course, an indication that you are signing on behalf of your company. All right, that's about it for our episode on agreements of sale. We have other episodes on real estate topics, LLC topics, and other business topics. Please visit Esquire Advice for that information. And also, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Thanks a lot, and I'll see you next time.